registered. This is how interruptions can happen. This is how disruptions can be happen. So let's just try this and get this analogy on IPRs. Anyway, let me again try and start if it continues for some time. That is, any startup, when you launch yourself into business, you need to see whether you need an IPR or not. Now, how do you know whether you need an IPR? Depends on the kind of product, the kind of service you're launching. If your product has got an international appeal, forget about it. If it's got a public appeal where you feel that this is going to become a brand, this is going to be something which is going to be known to people and a lot of people for that matter. So the next step is to see, you see a chance of when alarm bells should ring, and you should know that somebody somewhere can afford to copy this. So that is when I think the need for intellectual property registration or having an intellectual property gets triggered. So the first step is to first see what is the domain in which you will be operating your business or service. The moment you find that you are, obviously, I mean, it's needless for me to say, but there are some, B2B startups who are confined to one or two clients. They feel that one or two clients are enough for them. But that's rare. Most of the startups want to have a mass appeal, want to have a public appeal, want to go in public domain. You want millions and millions of your customers. So the moment you think of millions of customers, I think the need for intellectual property crops in. So I think you guys should be prepared to register. Now, the big question is that what is the advantage of having an intellectual property right? Obviously, this everybody knows that intellectual property right keeps you protected against the invention, creation, innovation, whatever you've done to your business, keeps that creation protected. Let me use the word creation as a general term for all the intellectual properties which you have created. Let me keep that word as a simple use word for rest of this conversation. So when we talk of creation, we talk of creating, once again I repeat, a brand, a logo, a trademark, a patent, or a design. Now the moment you create this design, first step is to develop this design, this trademark, this logo, this brand. Again, I'm using the word creation. First is to make this creation come into existence. After you made this creation, I think there is some research required. You need to research yourself. If this innovation creation is matching somebody, has your idea been already taken by somebody? If yes, has that somebody already registered it somewhere? Does that idea float around on the internet? The best way is to Google things out and you come to know, you get a basic idea. If somebody by the same name, by the same brand, by the same logo, by the same design, by the same trademark pre-exists. So I think the moment you find it pre-exists, a lot of startups do this mistake. They continue to sail through, they continue to move ahead. Little do they know that as they progress, you may be able to function in peace for some time, even that sometime could even be few years, but one fine day you might get a legal notice from that person saying that, sorry gentlemen, this is our design and you are no more allowed to use, we are willing to drag you to the court. So if you find that your design, your logo at an early stage already has an existence in some form on the internet or otherwise, because you can't get to be knowing the whole world at one go. So I think internet is the best way to know that somebody already exists. I think a very extensive Google search with some of your best skills of Googling, I would say, are required for you to be able to find out the answer. If you find, again I repeat that, if you find that there is an iota of feeling in you that something like this exists, I think that is where an early stage matters. When I use the word early stage, I meant when you haven't gone too far into it, you haven't invested too much money into it, you haven't used that logo, design, brand at too many places, you haven't gone into revenue making exercise, shall I say. It is time to make the correction. When you're satisfied out of your research that yes, my brand, my logo, my trademark, my design, my patent, my copyright seems like a unique one and nobody seems to be having it, it is time to go ahead and make a strategy. The strategy is that what am I going to do with this particular creation? Am I going to use it internationally? Am I going to use it only in India? Am I going to put it in public domain? Am I going to sell it in open market? And so on and so forth. There is a proper, are you going to earn simply out of the brand? Are you tomorrow going to franchise as well? So these are the questions which you need to answer to yourself. And in these answers lie the answer that what strategy should be made for taking this particular creation forward. Once that strategy is in place, it is now the time to register. And when it comes to registration, I have seen a lot of people going into do it yourself mode, DIY as it is popularly known as. We find that people go for their own kind of procedures, processes. Again, they Google it out. You do get basic idea of process of registration by Googling things out. Having said that, but because your creation is so precious to you, it is so valuable to you, it will become even more valuable with the efflux of time. I really, my personal advice is, do not do not register, do not process the registration, do not possess the intellectual property rights by do it yourself method. Because if you miss something out, you might be in trouble, whereas you feel I have done my best now, the process was all online, I did what was required. Having said that, let the experts handle. I think it's good to engage a lawyer or a trademark or a IPR expert, shall I say, to handle this for you. It may mean cost. I know that all startups are strapped for funds in the beginning, and you want to preserve the funds as far as possible. You don't want to spend on too many things, especially things which are not directly yielding revenue. Mind you, your IPR someday can become your biggest asset in the times to come. So do not hesitate in investing in the IPR. If you have to hire professionals, hire experts, hire trademark or patent lawyers, please do go ahead and hire them. It is a one-time investment, but at least you will be better informed. You will be, because those, they are the people who breathe IPRs in and out day and night. They know what is best for you. It will definitely cost you because they're going to charge their fee, but you will be secured. You will feel a lot more confident. You know you've taken the best step for protecting your creation. So I think that is the second mistake which a lot of startups make. They let me not spend money on. And at this point, let me inform you that Startup India mission launched by this government in 2016 has got a provision where your IPR, they can give you help. The Startup India division of the DIPP can give you help on registration of your creations, your IPRs, and you might end up saving some of your cost in the bargain. But all said and done, whether you go to Startup India, you go to a law firm, you go to an IPR expert in whatever form, I think you should definitely take professional help, because it is a one time, it's a lifetime investment. You never know. Do you know which is the world's biggest design, trademark, logo, or brand? Has anybody got an answer? I'm trying to read if somebody has got an answer. And what is the valuation of that particular brand? If somebody has an answer, if you can type it out soon, fine. Otherwise, I can't wait for an answer for too long because I need to carry on. Louis Vuitton at this point, as of 1st January 2020, although we don't have official estimates on record, but it is worth $50 billion, which almost comes to 3,60,000 crore rupees. If we convert it to rupees, that is world's most valued brand. And mind you, how brand has been created. Louis Vuitton is not a common man's brand. It's not a Coca-Cola where you just go and pick up from a store and probably buy a Coca-Cola for 20, 30, 40, 50 rupees. Louis Vuitton is not within everybody's reach. But you must appreciate that how much Louis Vuitton management must have worked to make the brand what it is today. Obviously, it's a luxury brand in the luxury brand category, but it is world's most valued luxury brand, although every other brand calls itself luxury. But that is one of the most. And why I mention Louis Vuitton in particular is I've got no no affiliations with Louis Vuitton. Why I mentioned is that the more the valuation of the brand, the more chances of infringement happening there. And little do people know, although I'm sure most people know that the most infringed brand is Louis Vuitton. I have seen Louis Vuitton on keychains. I have seen Louis Vuitton on back of a vest. I have seen Louis Vuitton on products where which Louis Vuitton never dreamt of making. So we've seen those brand names appearing on just about everywhere. Such is the level of and higher the infringement, it is indicative of higher the valuation. And again, not many people know that Louis Vuitton literally formed its own police. It had a full enforcement team across the world to see that it is the brand is not being infringed. Somebody told me that a friend of that somebody bought a fake Louis Vuitton bag from somewhere, and after using it for 2 years, that bag was put on sale online. And when somebody saw that bag on sale, that someone got a, of course I can't name the person, that someone got a call that, hi sir, do you want to sell your Louis Vuitton bag? May I know which year did you buy this? May I know what is the name of the model which you bought? And I think those questions, when they were being asked, the guy said, I'm going to answer these questions tomorrow because I'm not at home. When that guy asked the questions to the friend of mine who's also a lawyer, I think bells started ringing in his ears, and he alerted him that this is a call from the enforcement team of Louis Vuitton. And I think such is the extent of care and investment which Louis Vuitton has made in terms of protecting its IPR. So I think the brand can become so big that it may outsize your scale of business which you're operating on. So having invested so much in the brand, not protecting it is criminal, I would say. So that is the second step to be taken. Go ahead, get the registration done. Once the registration is in place, registrations are of many kind. I'll not go into the procedural part of the registration because we have some paucity of time. We've lost some time because of the connectivity in the beginning. And in 1 hour, I would like to be covering the entire sphere of IPR in terms of the declared topics which have been picked for this webinar. So therefore, I'll not go into the procedural aspect. But then there is a trademark authority, there is a registering authority in every country, in every city, in every state, whom you can approach through professionals, or if you feel you're good enough to do directly, please go ahead and do it. But whatever, it has to be registered. You can approach them. There is a process. There is a fee to it. You pay the fee. I'm talking of the government fee. There's a government fee, and of course, professional fee comes separate. That's not the same cost. So you pay the fee. You get it registered. When you get a intellectual property registered, the registering authority is not going to immediately give you a certificate of registration. There is always a processing time, and I think it is very explicable for the simple reason that you file for a creation. The registering authority has to investigate to see whether your creation deserves a registration. First of all, is it eligible for a registration? And one of the criteria for registration is that there should not be a pre-existing creation of a similar kind. I think that is the first and foremost thing which the registering authority would like to see, that there is no pre-existing registration in the same name. So after they have checked the normal period, I would say, although it's different for patents, different for trademarks, different for copyrights, different for designs, different for logos, and so on and so forth. But I would say a normal average registering time would be 3 months to 6 months, depending upon the kind of creation you are applying for. So we call this, in our technical jargon, we call this period as a cooling period. When you say cooling period, they have to, in fact, in case of patents, it's much higher. But why I call it as cooling period? Because the registering authority notifies that particular creation in an official gazette. It also notifies in terms of media. It's got its own media channels through which it advertises that, okay, if somebody has got a similar creation, please do come out with objections, because sometimes even for registering authorities, it is impossible to make out and be aware of what is happening across the world, not just the country. So there is a cooling period. After that cooling period, they might have some objections. So they will send you an intimation that we have some objections. Somebody somewhere has objected to your. What do you have to say? Is it similar? Are you the same person? Have you copied? Have they copied? What is the age of your creation? What is the age of other person's creation? So all those factors are taken into consideration, and of course, as the matter progress, no ex parte or arbitrary decision would be taken by the authorities. They will give you a chance of being heard. They'll call you. They will listen to what you have to say. They will take your submission. They will probably, in a remote case, connect with the other person also who's objected. And then a decision is taken like a court where final matters decided as to who actually owns that particular. Is yours original? If the other person is original, or if some tweaking can be done either way and both of you can coexist, and so on and so forth. There are various permutations, combinations of what can happen in a registration process. After you've registered, it is your duty to keep it protected. When you say you keep it protected, you should constantly be on the lookout if somebody is trying to breach. I have seen personally that it sometimes takes years and years to know if somebody has been breaching your particular intellectual property. So therefore, I mean, we take an example of, again, I took Louis Vuitton. I'll take Louis Vuitton as an example. Somebody in South Korea, I'm not talking of keychains in the back of the vest or, putting Louis Vuitton in places. I mean, won't be surprised if somebody is having a banana with a Louis Vuitton printed on it. So if we leave out those weird infringements, somebody opened a restaurant in South Korea called Louis Vuitton. And of course, when Louis Vuitton came to know about that violation, it approached the South Korean trademark authorities that this is a breach, and obviously the restaurant had to shut down. But there have been certain cases where even big brands have lost cases of infringement because of being careless. So it's not just the startups, some of the major brands can be careless and they can miss out on the intellectual property, in terms of registration. A very prominent example which comes, I'm sure we all know about Toyota and its popular car in India called Innova. So what Toyota did is, when it came to India, it registered Toyota as a trademark, as a brand, fine. Innova, it became very popular. It registered Innova as a brand. And Toyota has a very popular car in Middle East and Western part of the world, which is called Prius. Even in Southeast Asia and South Asia, it's got a car called Prius. And what happened is, Prius was not in India, and obviously Toyota felt there's no need to register Prius in India. And some of the creative minds here created some spare parts or spare auto accessories by the name of Prius. Toyota came to know about that violation. It approached the courts that Prius is our internationally registered vehicle name. It's the name of our brand. It's a mid-segment car. The matter went to Supreme Court, and it was decided that having Prius as an international registration, not having registration in India, by the way, does not give Toyota a right to have Prius as a personalized brand in India. Therefore, Toyota has got no rights to curtail use of Prius in India because Prius is not an India registered brand. So if you feel that your startup brand has got international ramifications, this particularly applies to technology-based solutions, technology-based startups, where world is the market, not just India. You can operate across the world. Your customer can be from the US, your customer can be from Europe, from Middle East, from Australia, from anywhere in the world. This normally is seen in tech-based startups when we are working in the virtual world. So when you feel that your startup, your brand, your particular business has got international ramifications, I think it is interesting and it is advisable to go for an international WIPO base, which is World Intellectual Property Organization. If some of you have not heard that, it's called WIPO. Approach WIPO for an international registration. It would be expensive because the law firm or whosoever is the IPR expert is going to charge you for handling your case with WIPO. It is expensive. It is an investment, but mind you, if you do not go for it, someone sitting out there in some remote part of the world is going to get the similar name, is going to get the similar design, is going to get the similar logo, brand, whatever, and you will suddenly find that they might get it registered internationally, and your creation, you may be fighting against your own creation to defend that sorry, this was my creation, and which is so true, but somebody copied it, got it registered, and had one up on that, and you might have to shut down or give up your brand. A very common example which I found is, have you ever found that when you try and register a website online, through GoDaddy or through whosoever, do you find so many times your names get registered rejected, even though your names are original? Because somebody, there are people across the world who are simply registering web names, popular web names, or common general web names in their names, and they are trying to sell those to people who really want. Well, this is a kind of an IPR which they are creating for themselves. They are creating that IPR for themselves, and for future investment, they're trying to trade in those names. I would say this is a kind of an infringement which happens even before you've thought of a name. So it's a kind of a pre-name infringement which happens, which they register in their name. And you can take my words, some of the people around the world are making millions and millions of dollars out of getting these domain names registered, which could just be your domain name, your idea, your mind thought about it first. It actually was your name, but somebody took it much before. So such is the importance of IPR. So once you've registered, it is your duty to keep it protected, constantly do searches. Some of the big brands, I must tell you here, they've got dedicated teams like Louis Vuitton, like some of the very big brands. They now have permanent team after what happened to. There's another very popular case of Bisleri. When Bisleri tried to launch, there's a cold drink here called a mango drink called Maaza. If you all heard of that. Now Maaza was taken over from Parle by Coca-Cola many years ago, and Bisleri tried to launch a Maaza drink in Turkey and some of the other countries, saying that they are exporting. Maaza is registered in India by Coca-Cola. It is not registered. It is not registered probably in some of the other countries. But Bisleri lost the case against Coca-Cola because Coca-Cola had got it registered internationally. Moreover, Maaza was registered in India by Coca-Cola anyway. So it was decided by the court that because Maaza was registered in India and an export activity happening from India is considered to be rendered in India, even though the end product is being used in another country. Therefore, Bisleri lost the case, and Coca-Cola was given the permission to stop Bisleri from using Maaza in any country because it was an Indian registered thing, and Bisleri was an Indian company. So I mean, why I mentioned these examples, that some of the best brands across the world, some of the best companies across the world miss out on IPR. So let's not talk of startups are very small, they've just started, so they are most likely to do mistakes on IPR. I guess, which is the purpose of CIRC doing a webinar of this kind, that is to create awareness among startups about the importance of IPR, about the processes involved in IPR, about the significance of IPR, and how IPRs can be leveraged to promote your business. Now, which brings me to the next step of IPR. After registration, you should start leveraging. If we go to the startup ecosystem, we find that the investing being made or investments being made in startups, you will be surprised to know, in case you are not aware, that a larger chunk or a large chunk of that investment being made in startup is going towards brand building. When we say brand building, we mean after you've created your intellectual property, you promote it in public domain. You take it forward. You move one step ahead, and you start promoting that particular brand. So once you start promoting and you start getting revenue, the valuation process starts. That is your creation, your IPR now commands a value. And startup ecosystem has been a game of talking of people starting startups not for profits immediately, but to build a valuation. I must say, in that valuation, the role of IPR is major. In fact, a substantial part of that valuation, startup valuation, may be constituted of the IPR. So I think which is very important. So you can very well imagine how important IPR is to a startup valuation also. So marketing of the IPR, valuation of the IPR, the protection of the IPR. Before that, of course, registration of the IPR. All these factors, they count in terms of understanding of IPR. I think we just have, my screen shows I'm left with about 12 to 13 minutes. Should I invite questions from you, please? If there is anybody in your the audience who's on the webinar right now, would you mind asking a question? You can type out a question and I'll be happy to answer. I've got my inbox here on my left of the screen. I can see what you're typing. In case you've got a question, please do feel free to ask, because I would love for this session to be more interactive where I could answer. Because as far as IPR is concerned, I can probably keep speaking for rest of the day. There's so much into it, but I don't want to go into too much of technicals of each kind of IPR. I would rather prefer answering specific questions which you guys might have. So, is there anybody who's still in doubt about whether to register an IPR or not, or if you got a question, your IPR registration had got stuck for some reason, you've got an objection, or how you can use the particular IPR? If you got a question, please feel free to ask right away. I'm waiting for your question to pop up on my screen. I can see something coming up. It says session now. Can now see and hear. Thank you, Dr. Kohli. How much do investors value? Oh, that's a billion-dollar question. How much do investors value? You mean IPR? Investors value. In fact, I would tell you, investors love to deal with startups whose IPRs are registered. In fact, they feel more secure, they feel more confident, they appreciate it more, and the chances of your getting investment, by the way, are far more if your IPR is registered. So therefore, I mean, as far as value of investors is concerned, it goes undoubtedly forward that please do get your IPR registered if you're looking for investors. Otherwise, investors might shy away from you. So therefore, I hope I've answered your question. How much do investors value? Of course, I can't answer how much. If you're asking for an objective or a quantum, obviously I won't know. It all depends on how much IPR value you already created. What is the worth of your startup? How much is your IPR worth? I mean, there are so many factors which decide how much. In case you're looking at a number, I hope you're not looking at a number, but in case you are, then I need some more parameters to be able to give you a fair idea. But generally, yes, investors do fall in love with the startups whose IPRs are registered. They feel that such startups are more professional. They feel such startups care for the investors as well. Imagine sit into a startup, invest a few $1 million, and suddenly one fine day you come to know that somebody has infringed that particular IPR, and your investment is worth zero because you've given a court notice to shut it down or to give it up. So it goes without saying that that investors really appreciate being an IPR registered person. Let me see if I've got some more questions. Can now see and hear the, what is that, the Gambia or something? Any other question which you have in mind? Anybody else who would like to ask something? Yes, I've got one more question from Aman Mishra. I have started a website with my friends, and I've got website on my friends, and on that we are posting blinks and articles related to fields of law. We are getting better along with the time, and our audience is also increasing, which is good. We are also looking for working on this for a long time, and for being a student, it's difficult to incur the expense related to IPR. Well, Aman, if the traffic is growing, it's a good sign. Congratulations, first of all. You are succeeding in your objective. You are reaching your target gradually, and I think yes, your question, your doubt is of many startups. That is, why should I spend? I don't have money right now to spend on IPR. But as I said in the beginning, I think you must have logged on later. It is a painful expense. I just met a startup last week, and they have created a navigation tool. Of course, I can't reveal the details here, but would you believe that the biggest investment, apart from development of the tool, 80% of the expense has gone into international registration of that IPR. Can you believe that? So major part of the investment which has been made in the startup is on account of IPR registration. So I know it's a painful expense. I know you're not in a position to spend right now. You don't want to spend right now. You're focusing on business development right now. You're focusing on increasing the reach right now. But imagine you reach millions and millions, and after all that effort, somebody decides to infringe your particular concept, somebody decides to copy that, somebody tries to launch it, and there you go. So therefore I would suggest, beg, borrow, steal, do whatever, but you must register the IPR. Despite the problems that you're facing, it is a must. If you have long term vision, if you are very optimistic, you're very bullish about this particular startup, I think you should go ahead. If you're still in the testing phase, you feel you're trying to see something whether it works or not, then it's fine. But if you're very bullish about it, you've done your research, your business plan is in place, you've done a market survey, you've done market research, yes, this is a doable thing, we can reach what we target, I think you should go for the IPR registration. Aman, I hope I've answered your question. I've got one more question. Oh, this is coming from Garima herself. Other than lack of awareness and paucity of funds, are there any other major reasons for startups for not going for IP? I think funds and awareness are the two main things. The only other thing, Garima, which I can think of is the procedural hassle. That procedural hassle, Garima, comes from something which I said earlier. Procedural hassle is only felt when you are in a DIY, do it yourself mode. If you're trying to do things yourself, of course, it is a hassle, because at startup stage there is so much to do in terms of business development, in terms of setting things up, that the last thing on your mind is to get into a legal process of registering the IPR, which itself requires a bit of time and energy and money, of course. So I think the only other thing which comes in the way, apart from awareness and paucity of funds, is the procedural hassle, for which I recommended in the beginning itself that you must take professional help. All you need to do is to approach an IPR lawyer or an IPR expert, who's then going to handle this for you. All your task is to supply the information that the firm wants, and thereafter let the experts handle, is the mantra I would like to say here. So there is no other hassle, because awareness, Garima, pretty much covers everything. Funds is the other bottleneck I already mentioned. So the procedure part, the time involved, the effort involved, I think is the only bottleneck which can be handled by experts. I got another question here from Faiz Siddiqui. Could you please highlight some shortcomings, if any, in the startup ecosystem that needs to be addressed by the government? Well, Faiz, our subject today is not particularly about the issues being faced by startup which government can resolve. I mean, our topic today is IPR only, but since you put up the question, I can say yes, government has a lot to do. It has done something, I would say, by setting up the Startup India mission. There is a separate department called Startup. There is a separate department called Startup India, head place called Vigyan Bhavan in Delhi. If you're not from Delhi, they have a separate team there which works day and night. It's got a portal, you can put up your questions online. There's a lot of help they are rendering. They are rendering help on IPR. They are helping you on funding. They are helping you in tapping global markets, formulating strategies. They are helping you on a lot of things. But yes, I mean, as a startup, when you talk of hand holding, when you talk of mentoring, there's a lot which is done, because a lot of services are digitally available. They're not available physical interaction with a mentor, which may not be that easily available. I think what they have done till now is better than not doing anything. But what remains to be done is a lot more. And I'm sure as startup, the other problem, Faiz, is that the startup community is not too bound They don't have a one single forum like FICCI or CII, which the other established corporates have. So I think they need to come together as one forum, which will be able to voice the concern to the government. Because when you voice the concern to the government, if there are too many voices being heard from different quarters, I think sometimes things go unheard in the noise. So when there is one word from one forum, one voice coming, that works. So I would we are trying to do something on that at my level, to have a kind of a chambers of commerce for startup, a separate chambers of commerce where startups can remain there till they are startups. Let's not forget, startup is not a startup forever. At some point you become a small and medium industry, and then you won't like to call yourself a startup for rest of your life. But then something needs to be done. You rightly pointed out, by the government. There is more needs to be done. There a lot needs to be. I cannot go into too much details first, because we are particularly talking of IPRs here. I've got one more question here. Any recommendations for the government to improve IP regime, particularly for startups? Yes, I think what the government can do. This is a good question. That what should a government do to improve the startup ecosystem as such? I feel that the government should have a separate registering authority. And my feeling is that startup registrations for the government should not be mixed up with established brands. I feel if government can demarcate startup registrations and not mix them up with rest of the established brand registrations, that will help in speeding up the registration. The time lag involved in granting the registration would be reduced, because what happens with registering authorities is they are clogged with too many registrations at one go. And there are, in those registrations, is a Coca-Cola application, is a Toyota application, is a big application, which is being scrutinized. Somewhere in between is also the startup registration, startup application. So I think there is a need to have a separate thing. Of course, a lot more can be done, but we can take it up another time. We're just about running out of. Government should provide enough incentives to startups can use good law firms. Yes, there are already startup. India has got a subsidizing facility. It can fund you. It can help you in registering, in fact. But it all depends. If you're going for an international registration, I don't think Startup India Mission will be able to help too much. I think basic services can be taken by Startup India Mission. But if you want to go for advanced registration, advanced searches, advanced protection, that needs to be done through law firms. So, ladies and gentlemen, it was absolutely a pleasure connecting with you, and I apologize for the initial connectivity issue. We lost a few minutes in the beginning, but I hope I've tried to make up for it. We can probably connect another time. CIRC can bring you on this platform once again. Thanks to Garima, the rest of the CIRC team who've been instrumental, and thanks for adjusting this. It was supposed to be happening yesterday, but then due to an emergency in my schedule, it could not be held yesterday. We had to defer it today. Thank you so much for your patience and understanding. And I hope after this webinar, you will all be having your own IPRs. You will all be registered, so that nobody ever again thinks of breaching, infringing your particular design. Your design is your own, and may it always remain with you. Thank you so much.